Hello, everyone. Can you hear me?
Yes, we hear you.
Yes.
Good. Good morning, everyone. I just wanted to say to you that Professor Maria is trying to unlock the room. So she is together with two students and they will start the lecture in a couple of minutes. Sorry for this delay and thank you for your understanding.
No problem.
It's not a problem.
How are you? How is everything going so far?
It's okay. I am using the time to finish the evaluation from yesterday.
Thank you very much for that. I will also use this opportunity to kindly ask all of you, some of you who were not present at the lecture yesterday, please take some time and fill in the evaluation forms that I provided you with via email. And today you will be given more evaluation forms for this particular course.
Anna, me čuješ?
Hi.
Okay. Hi, you guys. Very sorry, probably Anna told you, maybe she didn't, I don't know, because we had some slight technical issues here, starting from the fact that the amphitheater was not open, then we could not find the key, etc., etc. So very big, like a sorry from my side. And Anna, did you start telling them why are you here except to listen to my lovely voice on Saturday morning?
They know from yesterday that on each last lecture of each course, they will be given the evaluation forms for each professor. So I sent them an email yesterday for feminist, political, and legal theories, and we also did it online during the lecture. And now I will share additional links for professors for this course. So I would just kindly ask you to fill in these forms, take some time, and we will greatly appreciate more detailed explanation. For example, if you just give a grade, then we don't have additional feedback on the course, and we highly appreciate you giving us all the feedback that we can get, whether it's positive or negative. So what was positive, what was negative, what should we continue doing, what should we maybe change or consider changing. So with that, I will just now send you 3 links for Professor Krstic, Professor Bojana Čučković, and for Professor Vlajković. So let me know whether you received these links.
Somebody should respond if they see the links in chat.
Yep.
We can see the links, yes.
Thank you.
And for those of you who are in person, I just wanted to ask whether it's okay for me to send you an email now where you can access these links.
Jel može da vam pošalje u mail? Da. Okay, it's fine. Thank you, Anna.
So the email is sent. So you can see 3 different links. All of the questions are the same. And in the end, you have, most of the questions are obligatory to fulfill, but in the end, you will have like alternative option to give more detailed comment.
Should I fill it too? Sorry, no, I won't.
To je pitao I profesor Spajić. Može onda popun.
Did I give some nice words to myself, like, again?
No, he was joking about giving some bad words to colleagues.
To other colleagues, okay. Nice. Čekaj, samo da yeah, meanwhile, I'm downloading my presentations. That's why I'm downloading that one. Which one should I start first? This one, which I hate. Okay. All right. Okay, and then I'll go to the next one. Where's that download here? By the way, it's an exam day today at the faculty, and that's why there are so many people, and that's why they actually did take hold the keys. So I didn't know that. I completely forgot that.
Yeah. Yes. Yeah, today is the last day, so it's probably full of people. Did you go to Slava yesterday?
Yes. I have another student joining me live.
I wanted to take this opportunity to ask you whether you have any concerns, questions, or comments for this master program during this period that you had.
Well, maybe they'll have some questions regarding the preparation of the exam, how that will look like, and everything else. I think that would be their main question. Am I right?
Yes, that's correct. So we still haven't decided, at least I think we haven't decided if we'll be doing our exams in a written format or orally.
Okay. But what is also important for you to know, so within this month and a half or 2 months, you went through like 3 courses, and in January you will have 2 additional courses, mandatory courses, and then that will be the end of your first semester. So then you will have exam period, and then you have to register for the exam, and we will of course provide you with that information, and then you will take exams, and you will be giving for each course you will be having one professor who is the one who is examining you. So not all professors will examine the courses. That was the practice from last year. So I think that we will continue it this year as well.
Vi uradili ovaj evaluaciju?
Ne samo na putu dođe.
Eto, dobro.
Mislim, ovo što mi je juče poslata sada ovo...
Ima ovo što je sad, to je za nas 3, je li tako?
Okay. I see that one person submitted all the evaluations.
Until you all submit, we will not start. I'm kidding.
No, okay. I think that I will just kindly ask all of you once again to really do this, and we will again send you this link if you do not fulfill. I also want to emphasize that it's all anonymous, and that more detailed evaluation would be highly valued. So thank you for everything, like positive and negative aspects as well. If they're only positive, okay, then you can elaborate on that. If they're only negative, you can also elaborate on that. And we truly appreciate it for the next for the next course. This is a new master program, so we are open for changes and improvements, and your evaluation is very important for that. Okay, Maria, I will not take more of your time from your lecture. I hope you all enjoy, and if you have any questions or concerns, you can reach out at any moment. You can send me an email, or we can organize in-person consultations, and yeah, we can.
On the 31st of December. I'm kidding. The thing is, just I think that most of the questions will be directed towards the exam, just to prepare you, because they all have questions regarding should they write an essay, should they. What's the other option? The other option is to have an oral exam, right? With this, for example, mandatory course. And I think that most of them are not yet sure what type of exam questions should they pick, etc. So I think that's kind of something that they asked me in the previous classes. Am I right?
So I will. Yeah, I think that like probably professors will then decide how to examine. In the last year, Professor Čučković was the one who was examining this exam. So yeah, I think that I will then. Marija, jesi ti možda razgovarala s njima već o tom?
No, I think that I think that would maybe the best option. That we see which professor will be doing the exam, and then they could maybe have consultation hours within January or February regarding that particular exam. For example, this one, International and European Law. And if we know that Professor Bojana Čučković, for example, is the examiner, then we will tell her that the majority of students would like to know more about the modalities of taking the exam, and then she should then have the opportunity to explain to them how they prepare it. Okay, maybe that would be the best idea, just to know, or maybe I could tell them both, Ivana and Bojana, that maybe they could discuss with students after New Year's how they will prepare their exam. That's
what is important for you to know. What is for sure is that you will need the materials from the Moodle platform. Those materials that were sent by all professors will be used for your exam. So it is important for you to, we will of course discuss the format of the exam, but this is everything you need. All the materials are already there, so you can feel free to read them, go through them, ask questions if you have any concerns about it. So that's the important part, and I will of course forward your question to professors, and you will have feedback on that.
Yes, I did upload. I'll upload another presentation after this course, and I think that's it from my side.
Yeah, okay. And everything else is already uploaded because it was before. So yeah.
Thank you. Did you register another evaluation form that was submitted now, Anna?
Sorry?
Do you see that there are other evaluation forms?
Let me check.
During our short convo here.
Yes.
Okay, thank you.
Okay. Thank you, everyone. Bye.
Thank you, Ana. Bye.
Znaš šta sad mislim da će samo da će ceo meeting da ode? A ne, evo, leave meeting. Mogu da leave.
Can you leave? Can you go out? Goodbye. Ćemo expand window, maximize, share. Oh no, I forgot this one. Wait.
I believe there might be an issue since Abdik Sabeb is the host now.
Oh, right. Okay. What I'm going to do, I'm going to turn. Who is the host now?
Abdik Sabeb.
Okay.
I'll leave the name to
I am host. Now I need you to make me a co-host. If you don't know that, if you don't know how to create a co-host, I will. Could you hear me?
Yes.
Okay. Now I will just need you to end the meeting, and then I'll start the meeting again. Because what happened is that Anna started the meeting, then she left, and now I need to be the host of the meeting, and I don't want to bother you. So what I'm going to do, and sorry, once again, sorry for all the technicalities today. you are going to end the meeting and we are going to rejoin again. Okay?
It's all right. Okay. No
Okay,
problem.
just go like if you want to, if you go with the X and you don't go leave meeting but end meeting for all. Okay?
Okay.
values, we can say, values in their own meaning, whatever they consider to be values. So they all decided not to ratify the Istanbul Convention. And of course, the majority of reasons were related to the gender ideology, but also they were related to some other interesting questions. For example, asylum seekers. But we will discuss it later on. So let's go furthermore. When did the Istanbul Convention enter into force?
2023.
It's B.
Thank you. The Istanbul Convention entered into force in the European Union. So it's in the European Union in 2020. When did it enter into force in the Council? For the members that ratified first? Yeah, that's kind of the year when which were the first countries? What do you think? Do you know the Turkey was one of the first countries to ratify it? Yeah. Do you know which countries were the first countries to ratify the Istanbul Convention? There is also Wikipedia, but
Finland, Germany, Greece, Iceland.
Yeah, those are countries, Iceland, etc. Yeah. Okay. So, what do you think? We're going to go to number 6. Which of the following is true regarding the EU accession to the Istanbul Convention? There are several answers. I'm sorry that I'm in the dark, but it's easier for my students here to see a very nice screen here that we have. So which of the following is true about the EU accession? What do you think?
I see here that the EU signed it in 2017.
Yeah.
And it was, I don't know if it's the right word, ratified.
Yes, it needed more than 5 years from the point of signing to the point of exceeding, ratification of the Istanbul Convention, which is kind of a huge success if you consider it that was in the same period as this gender equality strategy was made by Ursula von der Leyen, when she said that the gender issues and gender equality will be one of the main topics and one of the main areas that the European Commission will deal with. And it happened. So happened that it was in that period 2025. So, but was the accession delayed? What do you think, due to legal and political uncertainty?
I'd say it probably was.
Yes, they were both. We're going to cover it now. It was both things. So it was not only political uncertainty. So we were not only talking about, the things that are usually controversial, we could say, about the Istanbul Convention. And those are this, as they call it, gender ideology, the question of gender and how you're going to define the gender, or what is even more so, how you're going to define rape as a criminal act and statutory crime of rape, because not all member states define it in the same way. But it was also the question of legal accession, meaning how you're going to cover, having in mind that the Istanbul Convention covers a lot of aspects dealing with criminal matters. And the European Union does not have competences in all of those aspects. So how you're going to legally deal with the accession, ratifying one convention, but making it obligatory only in those competences that you have within. And you can impose Istanbul Convention only when it comes to, and we will see, 2 domains that could be covered also by the Istanbul Convention. So it was very legally challenging, and that's why they waited 5 years. They even waited for the opinion of the Court of Justice of the European Union that was delivered in 2019, where the Court of Justice said, yes, it is legally possible to ratify a convention which has a larger scope of application and making it obligatory only in certain pillars. So it was very challenging in that way as well. And but that was also politically kind of very demanding, because the countries such as Bulgaria, Hungary were very happy that the Court of Justice took its time to bring the decision or the opinion, that it was in the Council for years until the moment they decide to ratify the Istanbul Convention, etc., etc. It was very, very demanding politically. And as it happens, so everything that goes in the European Union is even, I would say 99% of the cases more politically demanding than it is legally demanding. So we went through number 7, so we know that. Number 8, opposition to ratification in some EU countries has been linked to debates. So we know its definition of gender, but it was also this number B, obligations on domestic violence laws, because you know that when you not only sign but ratify Istanbul Convention, you need to make not a lot, but some amendments in your domestic, not only domestic violence laws, but other criminal laws that you have. And it's very demanding for a member state to do so because it has a certain deadline, it has certain costs, and member states are not really willing on doing it in their own time that they have. So it's also not because of the definitions that were given in the Istanbul Convention per se, but also because I would say the implementation obligations that member states have. So it's also number 9, the Istanbul Convention requires states to adopt laws. So, prevent violence, but also to protect victims. So it's A and B, and of course it's not C. And then, this, which was the first nation that wanted to ratify the Istanbul Convention when it opened for signature. We just responded. There is not one, there are several, because actually Istanbul Convention could enter into force only when 11 member states signed it and ratified it. So the EU accession it was 10 and then the 11th went really quickly afterwards. So the EU accession to the Istanbul Convention means what? This is what I talked about, and what would you say, based on what I said very shortly, what would you say, what does it mean? From these 3 answers that I actually put here.
I think that they have it's B, and the countries have the right to say it's not a state.
Yeah, they still can individually. Why? Because, for example, if you have Bulgaria, which is a member state of the European Union, but has not ratified the Istanbul Convention, you cannot really make or impose on the national institutions or even on Bulgaria to implement or even apply Istanbul Convention in the areas where the EU does not have competence. It would be against the whole EU treaty pillar structure. So only in those competencies where they're compatible, and when the Istanbul Convention actually covers by the EU competencies, you can apply everywhere in each member state of the European Union. Okay, so this is very easy. Which institutions were also involved in the debates around the Istanbul Convention? It was in the Catholic states, as we said, in the very, I would say, traditional oriented states. It was church that was from the very beginning, even though it sounds funny, kind of what church can influence a ratification of an international agreement. It was the church that had a saying, especially in Bulgaria. And also in Czech Republic, but in Bulgaria, it was actually, there were meetings. It was the case with us as well. There were the meetings with the heads of the church. In Bulgaria, it was the Orthodox Church, where they decided, they had a strong, I would say, advice from the head of the church. Yeah, I don't know that very well. To not to ratify the Istanbul Convention. But also what was in other countries, for example, the debates, of course, about the family values and the traditional role of the family and traditional role of the gender. And of course, what is the bottom line, and it always happens, also happens in the member states that have not ratified the Istanbul Convention, it's always the issue how marriage and gender is defined in the Constitution. So it so happens with the other laws that should be ratified, for example, in the Republic of Serbia, we always come to the definition of marriage and the definition of family in the Constitution. And then we come to the question, which is even more meta-valued, that is the question of constitutional identity. So, for example, if the identity of your Constitution is found in the definition of the Constitution. And if the definition of marriage is the, as we say, between a man and a woman, could you then change it, as they consider it, with laws that are beneath, meaning below the Constitution, that are derived actually from the constitutional values? So it's always kind of the debate on what is the identity of your Constitution, and can it be kind of nuanced or changed with the ratified conventions or with the newly imposed laws? Okay. So, Latvia, you answered. I asked you. So we're going to now start with the other presentation that I'm going to share with you. Just a moment. Sad dok meni skinula. Koliko mi je sad? 75? Sjajno. Super mi ide danas. I did it. Let me just share. Ne otvaraj se 5 puta. Sorry, do you see the presentation now? You're having network connect. Okay.
Not yet, but it's loading. Yes.
Is it still loading? Because now
Still loading, yes.
Lovely. Because they say that I have network connection. Okay, I'll try again. Wait. Pa ćemo opet. Ali sad nije ništa otvoreno, a? Ovo nije. Još je veći plan, sad već na... Sad, I'm going to try again, sorry. Da sad je opet 75%. Sad idemo. Ovo. Oh, Bože, molite se na to. Is it all right now?
Yes, it's visible now.
It's all right.
Thank you. Okay. Let me just, Oko prošli put kad sam Dragici na nešto, tako. Neće se otvori. Slideshow. If it doesn't work as a slideshow, I'm going to do it manually. So, okay. So firstly, what we are going to do today is, as I said, the overview of the Istanbul Convention. But before talking about the Istanbul Convention, we need to know one thing, which I mentioned in the previous class, and that is that the European Union, prior acceding, meaning prior ratifying the Istanbul Convention, actually brought a piece of legislation on its own, meaning a new directive, which is a very important directive, a first of its kind. It's an EU directive on combating violence against women and domestic violence. So it's a very kind of similar legislative act to the Istanbul Convention, and it covers some certain areas which are kind of identical to the Istanbul Convention, but not all. And it was, and we will see, it was brought in 2024. It was in the making since 2012, meaning for 12 years they were discussing on firstly finalizing and then, of course, adopting and then entering into force of the EU Directive on Combating Violence. So why do you think, and this is a kind of a legal question, but why do you think that the EU needed both? So they were going to ratify, and they did, the Istanbul Convention, but they also wanted to have this directive on combating violence against women, if they're both dealing with the same matters. you can think about it.
Because this directive is from EU and the Istanbul Convention is from the other international organization.
Okay.
We want to have a safety net.
Yet it is kind of a safety net, but in what way it is a safety net? Meaning that, of course, EU directive is not only brought but implemented by the EU. And on the other hand, this one, the Istanbul Convention, is kind of just acceding, the EU acceding to another document. So why do you think they would need both?
In order for states to make it a part of their national systems, maybe.
Yes, if I connect your two answers, that will be kind of the whole answer. Because that's why we had this introductory kind of discussion. Because if you take into consideration that not all EU member states are parties of the Istanbul Convention, that means, as I underlined, is that only in some scopes, meaning in some parts, you can make those member states apply a very important law regarding, or legislation regarding combating violence against women and domestic violence. But if you create and then, of course, implement a directive, its own goals and its scope will be obligatory for all member states, disregarding the fact that they are parties of the Istanbul Convention or not. This directive and its own goals, meaning its own aims, are obligatory for all EU member states. So that's the difference. The Istanbul Convention is not, yes?
I have a question, because the Istanbul Convention was brought to the court.
Yeah.
EU. Does that also affect this directive?
No, the directive is not affected by the Istanbul Convention. That's also great, because this directive was actually brought to make kind of a sharp distinction between the Istanbul Convention issues and this convention, which was kind of problematic in its own matter, but it's not related to the Istanbul Convention. They wanted to make a separate document, completely separate document that had similar approach, because it dealt with the same manners, meaning firstly women, violence against women, gender equality, and of course domestic violence. That would be what is kind of similar is this fight against patriarchal stereotypes, traditional stereotypes, systemic inequality, and again, of course, unequal partnership relations, family relations, and then violence. Those are the same, I would say, basis and the same foundations of the both documents. But in this document, you cannot debate if it's applicable or not, because if it is, I would say, voted in the both institutions, as we learned, it was proposed by the EU Commission and then voted by the Parliament and Council, it becomes obligatory. You cannot really question if you're going to implement it or not, and you have to implement it in its entirety, meaning every goal or every aim that was given in the directive should and has to be implemented in the given deadline. And here, you only, with the Istanbul Convention ratification by the EU, you can only count on two aspects that we're going to deal with. That's some criminal matters and asylum, because those two competencies are covered by the EU, nothing else. Member states of the EU, which are not parties of the Istanbul Convention, are not obliged to implement and enforce any other part of the Istanbul Convention. So that is the difference. That is great that you said a safety net, because this created a safety net. It was like this: we are not sure when we are going to ratify the Istanbul Convention, because at that time when this directive was created and it was in the making, they were not sure if they are going to succeed politically in ratifying the Istanbul Convention. And they wanted to make something that is kind of similar. It has even broader aspects, and we're going to see where, and that would be obligatory for all member states. And that was one of the top, I would say, top goals of the gender equality strategy and the von Leiden's commission, first commission and now the second commission, this directive. So it is kind of the first modernized approach to gender-based violence and the first of its kind in the EU.
May I ask you just a more practical question? Is there a possibility for the another president of the Commission to decline this, to say it's not?
No, because then they would need, again, it goes the opposite way. Then it would also need to be accepted in the Parliament and in the Council. And Council is, I would say the Council is, in the Council you have member states, representatives of each member state of the European Union, and the Parliament you have 735 member parliamentarians. So it would need to be accepted by the two of them. It could only be proposed by this president. For example, a new president comes and says, we are not going to deal with this directive anymore. But the president of the EU Commission has only the proposal power.
Yeah, but the whole legislative.
Yeah.
Is there a possibility for this directive not be used in second mandate?
No, it has an article in the Treaty on the Function of the European Union if you are going to decline or withdraw from a certain directive or a regulation, and it has to be through a very, very strict procedure, and you need a qualified majority in the both institutions in order to do that. So it cannot be done only by a unilateral decision of a commission or a president of a commission. It's not going to happen, especially, have this into mind, the new president of the EU Commission comes, but the countries already implemented in their own national laws, so they would need to extract those articles and provisions in their own laws in order to reverse the effect. So it would be very costly, very demanding, and it will take another 5 years or so. So I don't think, it never happened. It never happened so far. And I don't think it will happen because countries also have the right to leave in their own national legislation what they already done by implementing those obligatory provisions. So, as you see in the last, maybe you see it in the last paragraph, the adoption, why it was very difficult, because as you see here, it was which definitions were very, very difficult to implement. It was the same as the Istanbul Convention, so the definition of gender, but also for me, what was the most striking is the definition of sexual violence. So not all member states agreed upon what could be I would say, the fine line when the sexual violence starts and what could be defined as a sexual violence, and especially, as I already mentioned, rape. So it's still the question and the issue. And if you want to know more about it, I can send you some materials. And they have not, that's kind of the most striking part for me. They have not adopted this directive until it was cast out of the directive. So you don't have the definition of rape and sexual violence from in the directive because of the opponents in certain member states.
But there are these terms.
Sorry, there are terms. Of course there are. There is not a definition that was more strict that the Commission wanted. The Commission and the Special Commissioner for Gender Equality asked for a very strict definition of what could be considered as sexual violence and what could be considered as rape. But then they said that they're not going to adopt, they're going to oppose it in the Council. And what happened is they adopted, but they said, I'm not going to change my criminal laws in order to convey to the directive. That was the problem, because you need to change criminals. We did that as well with the Istanbul Convention. And imagine if you need to do it firstly for the Istanbul Convention and secondly for the directive. So it kind of is double demanding. A lot of countries wanted to get that, and they were very pro, but you need to be, in some ways, you need to have this qualified majority, and in the Council, in order to be adopted, you need to have a unanimous decision. So it was very difficult to achieve it. So as I already mentioned, and you will have this is kind of just a story that you will announce. If you get the question, imagine you get the question on this directive, you start with this one, like it is part of the Gender Equality Directive, blah, blah, blah. It's kind of what was the motive, not only equal work, equal pay, but also to deal with gender-based violence, etc. And here I put a video, the promotional video of this Commissioner for Gender Equality in the European Union, where it was explained what were the goals of this directive. And then what is more important for me is this part. So even though it was from 2012 until 2022 in the making, in 2022, the Commission proposed the final draft. And it took 2 years from the proposal to the adoption. And then what is even more important is it's still not implemented because countries have a very prolongated deadline, which is until 2027. So it was adopted in 2022. Its entry into force, it was in 2024, but they had 3 more years, so not usual 2 years, but 3 more years to transpose the provisions into their national legislation. And this is the yellow one. I did it, as I already told you, I always put in yellow what I think is the most important when you want to mention something about this directive, is this one, what it targets. So these are the areas that it targets, and those areas are kind of copy-paste from the Istanbul Convention. So criminalization, and then sanctions for the offenses, then victim protection, and enhanced, well, and maybe I would say improved access to justice. Regarding the Istanbul Convention, now I think about it, do you know those four, the pillars that are in this Istanbul Convention? That is something that you should look for. Those pillars is kind of, this is like, if you don't know anything about the Istanbul Convention, you can mention those 4 pillars. I think you have it online. Anywhere you say Istanbul Convention and pillars, it kind of falls because it explains in one sentence what is the purpose of the Istanbul Convention. Let me just see if the Google is not lying to you, because I said you can find it in one sentence and then, okay, wait. Istanbul Convention, like it applies for the member states. Let me just see if it is Googleable. Yeah, the 4 pillars. Okay, good. It's very well done, neatly done by the AI. So what it does is like you need to know, and you will probably be asked the question about the Istanbul Convention. Is like it's the Council of Europe Treaty, blah 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 blah, and it is founded on the 4 pillars that are then, I would say, delivered by all the provisions. But those 4 pillars are firstly prevention. It's kind of, in order to know about the gender-based violence, you need to raise awareness, you need to change stereotypes, you need to fight the traditional stereotyping, etc. So its first pillar is prevention. Second pillar, and it is one of the most important one, protection. Protection is recognizing and supporting who are the victims of gender-based violence, not only women, but also, I would say, everyone that are involved in the domestic violence. And then what else is also important for the victim protection? It's not only to recognize them, but to offer them help, shelters, helplines, this SOS helpline, etc. So this is also under the second pillar, protection. Then the third pillar, equally important, especially important when it comes to amending criminal laws, it's prosecution or criminalization. So you need to criminalize some violence. You need to have, this is kind of what, criminalize violence, criminal certain offenses, like, for example, stalking. It was something that was not criminalized in 60 or 70% of countries. So you need to criminalize when we talk about cyber harassment, etc. So it's something that we need to achieve. But stalking, or as we said, we wanted to have a different definition of rape, which was not achieved, unfortunately. But for example, female genital mutilation, which also affect, that was also the part of debate. For example, we are not, because we're in the European Union or we are in the Europe, female genital mutilation does not exist. It exists only in the African countries. Not correct, because where do all asylum seekers and refugees come from? They come from their own traditions, and it happens on the European soil. It's not extinguished because you moved from Africa to the European soil, so you need to have also female genital mutilation to mind. It was also controversial here. I don't know if you remember when it was introduced in the Serbian criminal system, because it is introduced, because usually it does not happen in the Republic of Serbia, but it was our obligation in accordance with the Istanbul Convention to change it. So third one, as I said, prosecution. And fourth one is policies, meaning coordination of policy. that is something that we call soft law, but it's also actions by government, actions by institutions, etc. So this is those 4 pillars are the crucial ones for the not only prevention but combating violence. That's why the Istanbul Convention is called the Convention on Preventing and Combating Violence and Domestic Violence. So because it involves these 4 pillars. Okay, and it's very unique in this other piece of legislation that I'm talking about right now. It's not the case. You don't have those 4 pillars, but they are deliberately delivered in different provisions. It covers basically the same in the same scope. Okay, so that was kind of a short nota bene on the Istanbul Convention, but we come back to the EU Directive on Combating Violence. So what is very important for the member states? This is the first, that this is kind of the goal of the whole directive, this one that we are talking about, is, as you can see, you can now recognize some pillars of the Istanbul Convention here. First, to take measures to prevent the cultivation of harmful gender stereotypes. And then in order to do that, you need to, of course, implement preventive measures. And this is Article 21. So Article 21 here, the last one, the last paragraph, actually covers the first pillar, prevention. And it's very important to recognize that here Article 1 really has a very, very broad scope of what are the prevention measures. So it really wants to tackle the traditional and societal roles of gender, well, I would say gender discrimination that exists in all EU member states. Then furthermore, we go to the next one. This one is the most important one for me because it deals with the second and third pillar, we could call it. And this is what were actually the provisions that deal with criminal conduct that could be defined as violence against women and domestic violence. And why did I underline these parts? Because this is where you can see the difference between this directive and the Istanbul Convention, because it covers more. It covers more. You have cyberstalking, cyber harassment, cyber flashing, for example, because it does not exist. Do you know what the cyber flashing would be? Yeah. Yeah, because it's actually, this is the first document ever that talks about and criminalizes cyber flashing and cyber incitement. Cyber incitement could be criminalized but defined differently in the national legislation and the Istanbul Convention. But in here, cyber flashing, because it exists, of course, everywhere, and we know it, but it's not defined per se as a separate criminal conduct. But here it is. So it's very important. It kind of has a broader scope of criminal conduct that should be implemented in the provisions of every member state. And then, of course, there is like cyber incitement to violence and hatred. So it's not defined. This is also very important. Cyber incitement means you're not only participating, you kind of, I would say, spreading the word of violence, but you're inciting, meaning motivating other people, for example, on social networks or online, to deal with hatred towards women, etc. So this is also important. Those are kind of what we had in Serbia a lot. And then look at the offenses in the last paragraph of this slide. What could be, of course, what could fall under the definition of violence against women. So it's not only rape, sexual harassment and abuse, it's femicide, which we don't have here with us. I think Croatians, they introduced it, right? If I'm not wrong, last year in the Republic of Croatia, or they wanted to introduce, they had the initiative in their parliament. Slovenia as well. So here, Croatia and Slovenia, whatever the outcome will be, they will have to do it because of this directive. So they will have to define the femicide. They will have to introduce it in their own criminal system. And that not only that, but also stalking. Early marriages, of course, already dealt with. But for example, different forms of, as we said, cyber violence, and then cyberbullying as well. So you don't only have sexual harassment, but also cyberbullying. This is also very important because in the directive, it deals with minors. and what the cyberbullying means, not only for minor girls in the sexual sense, but also for any, like they say gender. They don't, I would say they don't, this is also very important. There is, in this directive, there is no kind of binary definition, men and women, meaning based on sex, but it's very, very it deals with gender issues. And this was also very problematic for, as we said, traditional member states. And as I already told you, because this will be sent to you, I always put what are the most important innovative parts of this directive. So these are the innovative parts. When we compare Istanbul Convention and the EU directive, it has more innovation when it comes to criminalization and offenses that are offered in the provisions. So have that in mind if you if you get this question. If not, it's also important to know, because why? We also have to harmonize with this directive one day. We would have to harmonize, because in order to, let's say, exceed, even though how funny it sounds, in 2025, we would have to harmonize with all gender equality directives that exist, starting from Equal Pay, Equal Work Directive that was in 2006, up to this one that was adopted and entered in force in 2024. So around 20 directives that need to be covered by the Republic of Serbia. Okay, then we pass to this. Why do I think, if you could read it, hopefully you can, why is this important? The first paragraph. Now you're going to have some troubles with your site, but sorry. Yeah, it's very difficult to read. I can. You online have a better view of the PowerPoint presentation.
The gender neutral.
Yes, this the definition of the victim. It's even this is also a progress, a legislative progress in the not only in the European Union but in Europe, because victim is defined in a very, very gender neutral manner, and it's even a departure from the, as I said here, Istanbul Convention. So in the Istanbul Convention, you don't have it defined in that way. So this directive is kind of even more progressive when it comes to the domestic violence definition and the definition of the victim. So if you want to know what is one of the most, I would say this was the most important one. If we talk only about the gender issues, this was kind of a very difficult matter to overcome when it came to political discussions in the council. And then in the proposal, it was stated in that way, and kind of I think this was also a political a deal. If you don't put the definition of the sexual offense or rape, we're going to leave this part, and then it was kind of balanced in between what they let and what they didn't let go into the final text of the proposal of the directive. Okay, so this is for you. I'm not going to open it now. This is because this PowerPoint will be sent to you and it will be uploaded on the Moodle account. If you deal with anything, not only in this course, but anything, for example, in the legal clinic, etc., I provide you with all links where you can find the most relevant data and stats regarding gender-based violence in the European Union, but also in every member state and in every candidate country of the European Union. Okay, so I'm going to deal with some other part, and then we're going to make a short break. So this is where I make, because probably one of the most used questions, most oftenly used, is if you want, and you can compare this directive in comparison to the Istanbul Convention. So this is something that I made for you to make it easier for you to understand the comparisons. So as I already explained, the Istanbul Convention, when does it apply, etc. But And the third paragraph is kind of the most important one, as I mentioned, is that the convention does not address specific forms of digital violence and other cyber violence that was mentioned in the directive, and which the directive exclusively includes. And what is also very important, that's the last paragraph, and maybe that's why, again, I turn to you, as you said, to cover everything and to have a safety net. The last paragraph actually explains the safety net that we can have, and this is the enforcement. How you're going to enforce the EU directive differs of how you're going to enforce the Istanbul Convention. So, because the enforcement mechanism, for example, if you don't implement and transpose the EU directive, the EU Commission can also deal with you, and then you can go before the Court of Justice. It's not the same way with the scope of the Istanbul Convention. So the enforcement mechanism and the monitoring is stronger and even more stricter than it is with the Istanbul Convention. And that's why you perfectly explain it as a safety net. And then this is not right now. No, this is not for you right now. This is for you in order to have it when you read, if you want to prepare something from regarding this directive. I actually wanted to kind of summarize the whole directive to you, because I know it can be very tiring reading 30, 40 pages of provisions in the directive. And just to draw your attention to maybe, I would say, gaps or some lackings in the definitions that were given in the directive. So firstly, I think that maybe you mentioned, did you cover the part of intersectionality somewhere? Yes. So intersectionality here was given in a very, very vague terms. It was very general. It was not covered in any kind of more detailed manner, and it was just covered in the preamble, and then given that the directive has a very intersectional approach, but it was insufficiently integrated into provisions of the directive. While it's very important, because according to the stats and data that exist in the European Union, violence is not only, as we already know, towards women, just women as a category, but it has a very, very intersectional background. And it should be covered and integrated into directive, because it covered diverse groups of women, and which are very, not only marginalized, but in a very, very vulnerable position because of this intersectional background. And it's a very, I would say, kind of a gap that was not covered in the directive. The second one is, as I already mentioned several times, this is, and you will read it about the definition of the rape and the sexual assault. So, and then it is said, and this is actually what I found in a very, very nice academic article. It says there is still no, and this is kind of worrying, there is still no EU-wide, meaning unified EU, legally binded and consent-based definition of rape. So it leaves not only survivors and victims, but also when you want to criminalize, it leaves them with no, I would say, solid background and legal background to be covered if they want to deal with this directive before the national institutions, because it leaves actually member states as it was. Mm-hmm. So it kind of does not, not only enforce, but it does not give a stronger position to a victim par rapport what it's given by this definition of rape. And it was, of course, and that's the last sentence in the last paragraph. You don't see it, but I'll read it. So it says, if this was not removed, perhaps none of the benefits would be reaped to the citizens of the EU, meaning that the directive would have not been entered into force if this definition was not removed. And says, however, we can be certain that this leaves behind rape victims in the states which have not ratified Istanbul Convention in a very, very vulnerable position, because it's not defined in the directive, but it's also not defined but not implemented in those countries like Bulgaria or Czech Republic, which have not implemented the Istanbul Convention. So you have a lose-lose situation. It's not covered. But it was a part of the political consensus, unfortunately. Okay, now it has been an hour because we had an evaluation. We're going to have a 10-minute break and then we're going to continue, okay? So you don't die to me in front of me on Saturday, in the last Saturday of December, okay?
Okay.
Yeah, 45 minuta nakon toga. Neću produžavati, don't worry. Ja to sad ne nosim od kad znam sve na kompu. Sad ću radim kemijsku, neću ukrasti. Evo, ne, tušite. Hvala. Jeste. Nemamo. Pa ne znam, vi imate nešto puno, koliko ja shvatam, imate i Dragicu i ne znam koga još. Šta ste još imali?
Imamo Dragicu, imamo... To je Rasman za Dragicu. Da, pohvatam kasu, ali ja ne znam li imamo nešto.
Da, šta imate u januaru i februaru?
Krstićka nacije, Maja Lukić...
Feminist Judgments, dobro. To je Ivana Krstić i Bojana Čučkovića, tako? I Tanasije, da. Ma kako, imam sve, hvala. Or should I say no? Okay, we continue now in order to be as speedy as possible. One of the things that I wanted to ask you, because it's usually written in a lot of proposals that were not only from the side of the EU institutions such as the EU Commission, but also from the NGOs that were really rooting for this EU directive, it was written that if there were not European legislations that deals with gender-based violence, then the EU could lose, and this was really exact, the EU could lose and loses a lot of money. Why do you think that the gender violence costs? How do you think? In what manners?
I understand it. And it's also the argument of inclusivity of LGBT people. It's when you have the obligations and policies and you follow them, then the satisfaction from your employees rise, and then activity will rise, and then it will also bring more people to your company.
Company success.
Company success.
Yeah. It was actually one of the, well, for the EU, this is why I ask, because as I said in the beginning, when we start analyzing the EU legislation regarding any gender issue or gender equality or men and women in general, equal pay, equal work, it always revolves around, as I said, the economic issue. So what was done from this, what is the main, and I mentioned it several times, is the Gender Institute, European Institute for Gender Equality. And when it was actually initiating and very supporting of this EU Commission initiative, it did an analysis where it estimated the gender-based violence costs, meaning what were the costs of the EU annually. And it says it was more than 226 million annually that EU loses because of the gender inequality in the EU in general. And the question was how it loses, and so what were the streams where the money is lost. And this is firstly, again, as I said, everything revolves around the EU market. It's firstly the access to the EU employment schemes, and then actually access to free movement, and then access to EU labor markets. Then this access to EU labor market is, of course, connected to the women's financial dependency. Then this is also connected to the women's traditional roles that they should stay at home. Then this is connected again to the women's traditional role that they cannot actually buy anything from themselves personally, meaning using the services, then using the capital. They do not have their own bank accounts. And this actually affects all core freedom and the market in general. Then this is the one thing, the one stream. The other stream is gender pay gaps. So what we talked about, that's why the other directives were brought, because of the gender pay gaps that were kind of, would say, affecting the EU labor market again. And then imposed sanctions, because if there were more criminal offenses in the EU member states, it costs more for the state. Not only to penalize it, but also to criminalize it, but also to have enough, for example, prison states, but also to build enough shelters, but also to build enough protection lines, etc., etc. Then the imposement of sanctions. So if you impose a sanction, every sanction is very costly per each member state, and then annually per European Union. So regarding that, we also have a calculation and economic background that gender-based violence, and actually violence in general, domestic violence in the European Union, is a very costly manner that not only affects, I would say, on a personal level, families and women, but also affects the EU grosso modo. I would never start from this argument if you would ask me, but this was kind of a very, very pursuing argument in the EU, and that's why I wanted to say. Again, one of the surveys that was done by the This is what I actually put here, I think. This FRA EU-wide service. FRA is Fundamental Rights Agency. That is the biggest agency that exists in the EU, and it's an EU-funded agency that deals only with human rights and fundamental rights. And this was part of the initiative in order for this directive to be adopted. And according to the survey, around 13 million women in the EU had experienced physical violence, and I think around more than 3.8 million women in that year alone, so in 1 year, experienced some kind of sexual violence. So it was kind of a research which was an additional incentive for the EU member states to not only go further with the adoption of the directive, but one of the initiatives to accede to the Istanbul Convention and to take appropriate measures on the EU level. That's why I put it here. I put the links because it is updated regularly, especially this European Institute for Gender Equality. It updates every year, and it introduced Serbia as one of the candidate country here that is also surveyed. And then why I put here an Eurostat survey, because here how, for example, countries that have not ratified or do not want to ratify, some of them, Istanbul Convention, see they're most likely to justify sex without consent. This was done among the citizens in not only small, because they tend to prejudice and say in small towns or rural areas. Not. It was done in each capital city or bigger cities in Romania, Bulgaria, and Hungary. And it was really said that they are likely to justify sex without consent, not defining it as rape. And then that's why, for example, we see that with 2/3 of these states lacking a consent-based approach to rape. And that's why it was blocked. This kind of definition was blocked in the council. So see this alarming part, which I've really underlined several times, is the second paragraph. See, the directive merely states that the agreement also obliges member states to take rape prevention measures and to raise awareness of the central role of consent. Wow. So yeah, that's, see how many times I mentioned it. That's why it bothers me as well. Then one of the gaps that I also saw in this directive is the last paragraph that I mentioned, and this is how labor was tackled in the directive. So labor was only defined through economic activity. It was not defined through what the women carry throughout their life, and this informal labor was not included in the scheme at all. So kind of it was, as you see, it was a binary division again, like a traditional role of labor and actually occupation, and then informal labor was not only taken anywhere, I think, except in the first part in the preamble where it stated kind of the woman carries out the 90% of the majority of the formal labor. So these are the problematic areas of this directive. And what is also the most important problematic area that we will see from 2027 onwards, that will be implementation. So how actually member states are going to implement and transpose the whole directive throughout their national legislation, and what will happen afterwards when the EU starts monitoring how this directive is implemented and applied by their national institutions. So this is maybe the biggest issue to tackle in the future, because it's nice to have a set of wishes and well wishes in the directive, but it's completely other issue to have it implemented properly first, and secondly applied in a very, very consecutive and kind of a consistent manner. So now we come to the EU and the Istanbul Convention, which is a story that kind of parallelly took place in the European Union. And okay, this we went to. These are the pillars that I talked to you about. These are the core values that are covered by the Istanbul Convention. And why do I say that? Because those are the same values that are covered by the articles in the treaty, so they are matching. And then the third part is Why? The most difficult question is, why did the ratification took more than a decade? And we mentioned some of the things. So it's a legal complexity, which I will tell you now about. And then question of competences, which is also a legal question, but also I would say that something that prevailed were this value-based conflicts. So these were all the reasons that were kind of also behind the implementation and adoption of the directive. Those reasons were even more enhanced when it comes to the Istanbul Convention. So these are the resistance, of course, as I already mentioned. This is only for you to have if you want to cover it. Which country did not ratify the convention, and which are the main areas of concern for them. Okay, so firstly, before we start with the Court of Justice opinion, I'm going to just tell you a little bit about how it went from adopting Istanbul Convention. It was, of course, one of the goals since 2015, but until 2023, it actually came into force, and it came into force not just with ratification, but, and this is important because it's kind of boring, but you have to know it, the European Union ratified the convention in 2023 on the basis of 2 council decisions. So it did not ratify it by itself, but it needed to bring 2 council decisions that had to be adopted by all member states that concerned judicial cooperation in criminal matters, because it deals with the Istanbul Convention competence, and asylum, and prohibition of refoulement. Do you know what's a refoulement? Non-refoulement principle. Google it now. It's a very important principle in the most important principle in the asylum, migration and asylum law. If somebody knows online what's a non-refoulement principle, they are free to tell us.
Is it related to pushbacks?
Yes, it is related.
Will not, push back the refugees back to the country they previously crossed the border.
Yeah. But what happened in that country? Like, what happened in that country? Why can't they push back those asylum seekers or refugees?
Why?
Yeah.
Well, they don't want migrants, so-called, or refugees in their country for various reasons.
You are right. I just need to add something. So the non-refoulement principle is, of course, you are forbidden to return someone where? To a place or to a country or wherever?
Yeah, where for example, the death sentence will be executed,
yes,
or somebody will be in danger.
Of course, that's actually the bit. So you should not, and when I say you should not, it's basically forbidden in international law. This non-refoulement principle is an absolute principle in the international migration law, international human rights law. So you are forbidden to return anyone to a place, country, or wherever, where they would face any kind of harm or threat based on, and then we see what are the bases in the International Refugee Convention. So they would face serious threat or harm on their life, or they would, for example, be subject to an inhumane treatment or subject to torture or whatever. So this is kind of a non-refoulement principle, a principle where if you determine that there is a scope of harm or a threat to be subjected to torture or inhumane or whatever degrading treatment, you must not return that person to that place. So it's a kind of a rule against forced return. And this is something that is also implemented in these 2 decisions. So once again, in order for the European Union to ratify Istanbul Convention, it had to bring and enter into force 2 council decisions. One is regarding judicial cooperation in criminal matters, asylum, and prohibition of refoulement, and the other is regarding the functioning of EU institutions and public administration, because it, of course, deals and it involves their future dealing with the Istanbul Convention matters. So these two decisions were actually the basis for the ratification of Istanbul Convention. And something that is very kind of important for you to remember is if those two decisions were not brought, the EU would not have competence over Istanbul Convention. It is important if they ask you if for example, if directive that replaces Istanbul Convention. No, those are complementary instruments. So directive was something that entered into force and that was delivered by the EU institutions to EU member states. But Istanbul Convention is something that is an international background. It has a broader framework. It's less detailed, but it gives a strong international obligation moment for the EU member states and for the EU per se. And then again, I wrote an article regarding the accession of the European Union to the Istanbul Convention, and I wanted you to read it. And then I thought you should not read 20 pages of how it went legally. So I just kind of extracted some most important parts. And that is, what are the domains? If somebody asks you, what are the sphere of competencies or domains where Istanbul Convention is applied? You can answer that it's firstly regarding the migration and asylum, and secondly, criminal procedural law and cooperation in criminal matters. So those are the two most important parts. So migration and asylum and cooperation in criminal matters. When it comes to substantive criminal law, states that have not ratified Istanbul Convention are not obliged to apply it. And that's the biggest difference that you should know right now today. So in the sphere of competencies that I mentioned, the Istanbul Convention is applied everywhere as it is ratified and is a part of primary law. In other spheres, so especially regarding substantive criminal law and regulation of criminal offenses, the countries regulate themselves, especially those countries that have not ratified the Istanbul Convention. What else do you need to know about the accession? I will come to this court case afterwards. These two decisions were, of course, adopted prior the ratification of the Istanbul Convention. But as I mentioned, there was the opinion of the court that was brought in 2021, but it started in 2019. It was initiated, where the court actually gave a legal basis for the EU accession. So the Court of Justice was the one that said, yes, the European Union can legally accede to the Istanbul Convention, and this is the way how to do it. And it kind of draw a legal roadmap, I would say, how to create these two decisions, of course, and to make a sphere of competencies where it could be applied and where it should not be applied. But the court gave the green light for the legal accession to the Istanbul Convention, the Court of Justice. It says that, of course, this is something, do you know what's a mixed agreement? The international mixed agreement, what is that? That's kind of from the international public law. There are several agreements, not agreements, but actually treaties, and there is like kind of a mixed treaty. What should be a mixed treaty?
Within countries that are in the EU, but among
it is somewhat correct. It's also the mixed treaty. Oh, this is the best way I can give you. Do you know what's a stabilization and association agreement with the Republic of Serbia? Yeah. Stabilization and association agreement is a mixed treaty. Why? Because on the one side, you have the Republic of Serbia. Yeah. And on the other side, you have EU, but also each member state. So that's a mixed treaty. So each member state had to ratify the Stabilization and Association Agreement with the Republic of Serbia in order for it to enter into force, not only the EU. The difference between that and, for example, with Kosovo, there is a Stabilization and Association Agreement with Kosovo. It's not a mixed agreement. Why?
Because not all states confirm that Kosovo is a state.
Recognize Kosovo as an independent state. So what the EU did to overcome it, EU did a bilateral agreement. Only EU signed the agreement with Kosovo, and then it can only fall under the sphere of competencies of the EU, because they wanted to overcome those 5 countries that were not given, that they will not give their consent for that type of agreement. Istanbul Convention, again, is a mixed agreement. So every EU EU and every member state had to ratify the Istanbul Convention for it to become obligatory on the level of the EU. So Istanbul Convention is a mixed agreement. And the legal basis was delivered in the opinion by the Court of Justice in 2021. It's called the Opinion 119 because it started in 19, it took 2 years for it to be delivered by the Court of Justice. And one of the, actually, it's very complicated when you involve both member states and both in the EU when they're parties to an agreement, because it takes so many years and it's kind of very a complex legal but also political endeavor to overcome in the European Union. And I will now just skip that part and come to this decision. This is the case WS, and now it is for you just to see if you could find information regarding the WS case. So you have the information here. And tell me what happened in the WS case in 2020. Actually, it was last year when the decision is brought, but it was submitted to the court in 2021. So WS case C62121. Let me just see what happened here. If somebody finds it, you could tell me. So he or she, if you find it, you could tell me what's the main contribution of this judgment to the EU law and this whole discussion to the Istanbul Convention.
Is this for the case for the child marriage? Is that it?
I think she was not, I don't know if she was married while she was minor.
Is that the Turkish national
Yes.
origin who had been forcibly married?
As a minor, yeah, she was as a minor, but it was not due to minor marriage of the minor. Yeah, they didn't consider that. They thought that it was kind of part of, no, they didn't.
Experienced domestic violence.
Yeah, that's the part.
And like a face that's from her former husband and family is returned to Serbia.
Yeah, what happened is firstly, where it happened in Bulgaria.
Yeah, she thought,
So she ran from Turkey to Bulgaria, and then in Sofia, she and her lawyers at that time actually filed a complaint to the Bulgarian Administrative Court regarding her international protection. Meaning she was a refugee, she was an asylum seeker, and she was, as you said, a Turkish woman, yeah, but she was Kurdish, I think. And what happened is not only that she was married as a minor, she also suffered violence throughout all her marriage, and the whole family, including hers, supported that and made her return to her husband, who was twice imprisoned. But he was actually, I think he did half of his sentence and went out. So her family wanted her to again come back to him. So she feared that if she returned to her country of origin, meaning Turkey, she would be forced not only to remarry him, but to live with him, and again subjected to the violence, because even more so stricter, because she brought shame not only to them, but his and her family. And so what the Bulgarian authorities did, the administrative authorities, they rejected her asylum application, because they took the view that this prolonged domestic violence that she suffered, she also suffered from death threats by his family. It did not constitute like a relevant ground for the refugee status. But in general, you need to have like a ground. We talked about it. What should be the relevant ground that should be determined? And domestic violence was not among those grounds for the refugee status. And then she filed a complaint with the administrative court, and the administrative court stopped the procedure and referred the question via this preliminary reference procedure to the Court of Justice of the European Union in 2021. It had several questions, but one of the most important questions that formed this whole, and this is the first decision and the only decision so far that we have. The administrative court asked, could a domestic violence victim fall into a category of a particular social group, and that way, if she is a gender-based violence victim, particular social group could then be extracted to become a basis for the granting of the refugee status. So, second question was related, if Bulgaria is not, as it was not and still not, is not, if Bulgaria is not a member of the Istanbul Convention, should it apply that to, because the EU is a member of the Istanbul Convention? And then what the court did, and I will just skip it because I have the whole decision, it goes like this. With regard to the application of the Istanbul Convention, the court said the following. Convention is binding for the European Union since October 1st, 2023. Meaning that it imposes obligation regarding asylum to Bulgaria. So this is the first question answered. Second question is, when it comes to defining who can be part of the social group, it goes like this. The Court of Justice concluded that in order for a woman to be regarded as forming a particular social group, it should be established that in their country of origin, she is exposed by reason of her sex or gender, is said here, to physical or mental violence, including sexual violence and domestic violence. Meaning, the court said that even narrow groups of women sharing an additional common characteristic, meaning they're gender-based violence survivors, could be members of a particular social group, and thus it included not only gender-sensitive approach, but for the first time intersectional approach, meaning those are women who are generally refugees, asylum seekers coming from different religion or different race or whatever. So it was like a big decision brought by course, like a breakthrough from the course where it included, as you can see here, this is only the most important part, women are to be considered as part of a narrower particular social group in accordance with the Istanbul Convention if they are gender-based violence victims. And the second thing, it should be applied even to a member state that did not ratify it because it considered the competencies where the EU has exclusive competence over or shared competence, such as the asylum. And this is the most important part that you will have from this decision onwards. It's still not used as a precedent because we haven't had any other decisions that were brought. This was brought in 2024, I think in December, so it's less than a year. But it is the most important one because it will be used as a precedent in the future, hopefully. And this is also very important because the court gave an impetus that it will, future on, refer to the Istanbul Convention onwards when dealing not only with intersectional approach, but with dealing with asylum cases. So maybe this is kind of the most important part that you should remember from this this lecture. Sorry, I have two laptops, so now I need to see. This is the end of this part. So what I'm going to just show you, I'm not going to deal with it because we don't have time. We've been here more than 2 hours. I need to, deal with this. This is something that you can read. I will just go through it to show you what you need to read from the other presentation. Ova prezentacija koju sam pravila u onom nekom programu MacBooka koji je najgori program na svetu i mrzim ga, ne podnosim ga. Te moj brat rekao će biti mnogo lakše, kaže. Neće.
Ko je rekao da je MacBook logičan?
Strašno. Ne, nego sad dobila od njega kad sam doktorirala, pa ne mogu ga baciti. Ali je dok sam se ja navikla, to je katastrofa. Valjda vidim. I think they see you're about to share Adobe. Okay. This is now you see the changes that I made. This is a short presentation regarding women in the EU foreign security policy, and this is what I draw your attention to. You can just read through this, skim through this. It's not as important. The most important part is this. Let me just see, where do I underline it? Yeah, no. So you can read. I don't think that anybody will ask you this, to be sure. I know this because I had to know it in the external policy, but the part that I would ask you is this. Gender equality in the EU enlargement policy. So this is something that probably you can discuss on. So is gender or gender equality as a question, how is it treated in the EU enlargement policy? And was it included in the conditions or in the EU progress report? And how it is dealt, for example, in the EU progress report? And this is what I underline here for you. You can't see it, but you will see it when you open it. There are always 4 main questions that are dealt with where it comes to gender equality. This is, for example, you get the progress report from the EU Commission regarding the Republic of Serbia. There are always 4, again, pillars that are treated when it comes to gender equality. First is gender-based violence. Second is female labor participation in the market. Third is human rights. And 4 is political representation. So when you talk about the enlargement criteria, it's always part of the, values and political criteria that are very much regarded so, and they're always dealt in these 4 contexts. So you have it all in a presentation. And then, for example, for us, I think in 2025, I'll tell you now what it says. One of the most important, of course, problematic places is the Constitutional Court decision regarding the law on gender equality. And you can read it, of course. I don't know if you had the chance to read the open letter that the academic community sent to the Constitutional Court. But if you have, it's online. It's I think it was Tanasija Marinković who actually made that letter, and Ivana Krstic, etc. So it's interesting to read because it has a very good international background and what the Constitutional Court should have regarded prior suspending the whole law. But it was also discussed in the Serbia Progress Report 2024 and 2025. And then, of course, so gender equality and also gender-based violence, the issue of femicide, which I talked and I mentioned before. So these were the biggest challenges. And this is something from this presentation that you should remember. Everything else, it's not as important because, as I said, you can skim through it just in case. But it's all part of soft law and policies that are introduced through external action, and why are there no more women ambassadors and women part of the external policies, etc., and how women should be protected in the conflict areas, etc., etc. But as I said, it's not mandatory and it's not part of the EU regulations. With that, and this is in Instagram, with that, 2025 ends here. So I'll stop now sharing. Sorry. I will now just upload the previous presentations that we did for 2 hours on Moodle, and I'll send you a follow-up email. And then if you have any questions, you will refer it to me. Also, what I wanted to announce that in the next few months, it will be me instead of Anna, who will be dealing with administration of the law and gender. Of course, there is Professor Krstic, who is the head of the law and gender master, but it will be me who will be dealing with administration, I think, from January onwards. But you will be, of course, informed regarding that in an email, because Anna is leaving. She will not be long. She's moving to another country. She's not leaving for a bad reason. She's moving for a great reason. But it will be me who will continue administrating this course and administrating the whole master. But as I said, you now refer to Anna, and then when you get an email, it will be me, who you know now, who will be continuing the full administration and your courses, and afterwards master, defense, etc. Okay? Okay. I think we'll find now it's 1:20. Again, sorry for the delay in the beginning. I know that you're very sorry that you lost 25 minutes of this precious lecture, and I hope that you had okay time on Saturday. Well, I would say morning for me, but no, it's afternoon. And have a nice weekend. And if you need anything else, you know my email, and write to me whenever you had any questions or you want any information. Okay.
Okay, thank you.
Okay.
Thank
Have a
you.
nice weekend.
Thank you. And have a nice weekend.
It's been a pleasure.
It's been a pleasure too. Bye. Thank you.
Bye.